Howdy and welcome to the show. Cooper's Code examines a legal issue and hits the highlights so we all achieve the best results for our clients. I'm Miles Cooper, and with today's guest, Tim Micheal, pre-litigation case manager, we will be discussing legal writing and specifically how to craft effective demand packages by keeping things concise, simple, fact-neutral, so that the adjuster can get the information they need to be able to resolve the case. Before we get into today's topic, a few words about Cooper's LLP. We at Cooper's are committed to thought leadership, developing the best talent, and honing the skills through learning, practice, trial, and the relentless pursuit of justice for consumers. With lawyers licensed in California, Oregon, and Washington, we're available for free strategic consultation on cases, and we accept referrals and trial co-counsel opportunities. For more information, visit our website at coopers.law or email us at podcast@coopers.law. Welcome back to the show, Tim.
Thanks for having me.
So today, we're talking about legal writing.
What a subject.
Do you have a preference, not from a legal writing perspective, but from a reading perspective, when it comes to making decisions between a writer like Hemingway and a writer like Faulkner?
Being totally honest, I do not really have a preference, and maybe a little bit of background is useful, but I do not do a lot of reading for fun. I don't do a lot of fiction reading. I'm more of a nonfiction reader, and in reading nonfiction, the writing style is obviously completely different, so I really don't have a preference.
Good to know. The reason I have focused on Hemingway, not Faulkner, is Hemingway is known for those short, punchy sentences. Simple things said without a lot of extraneous material. Whereas I think Faulkner may be known for one of the longest intro sentences to a novel ever. As you approach the writing that you do, and we didn't do this in the last conversation, but in your role as case manager, does some of the work that you do involve writing?
I would say probably my biggest job responsibility involves writing, and that is preparing the client's demand package before we send it over to the insurance company. So I oftentimes am helping prepare the first drafts of these demand letters, which involves a lot of times writing 10 to 20 pages of a narrative about our clients' lives and the impact incident had on it.
And let me guess, when you call an insurance adjuster and they have had the benefit of your demand package, their response has typically been, "Oh my gosh, I love reading 20 pages of material about an individual. I understand that you may have other clients. I am not adjusting those cases. Could you send me their packages over too, because I just like reading this stuff so much?"
Yeah, it's funny because one of the most frustrating things is that I spend a lot of time and energy drafting these demand letters. And my hope is I send it over to an insurance adjuster. They're going to go, "Oh yeah, we owe this guy the policy." And they'll call me the next day and pay the policy. The vast majority of the time though, they take their full 30 days. They give you a call and they give you an offer, and they do not reference a single thing in your demand package. And when you refer back to the demand package, they say, "Oh yeah, no, we review the medical records," or something to that extent. It almost feels like the demand package itself is kind of an afterthought for the adjuster. They're more interested in the evidence that comes with the demand package. But the demand package is important because we're kind of setting up a bad faith situation for the insurance company to kind of walk themselves into. If we have not gone through the trouble of putting together all of the information that we have, all of our evidence in essentially a demand package, then it's not always very clear what evidence we've provided to the insurance company. The demand package serves as the essentially one-stop shop of your case. And you give that to the insurance company, and they may not act like they read it. They may not even read it. They may just look at the medical records, but writing it is still useful. It just may not always feel that way.
The direction I was headed with that was, in essence, kind of what you were talking about. Whether it is an insurance adjuster, a judge, a research attorney, opposing counsel, whoever is receiving the material that is being provided, typically is not there because they're interested in picking up your material because it's their version of Hemingway. More succinctly, they may go home and read something for pleasure at the end of the day. It's not the stuff that you're providing. So how do you go about making that information as simple as possible and as interesting as possible to be able to hopefully get the attention from the decision maker who is reviewing the draft of the material that you write and then the attorney approves in terms of it going out the door?
I would say I definitely adopt a more Hemingway style. When I first started in this field, I would say that I had a decent amount of experience writing, but I had not written in this type of industry. I had not written demand packages. I had not written for personal injury law. I was writing history papers or research papers, very different type of writing. But something that was drilled into my head from the very beginning is cut out those extra words, those embellishments. You don't need to say that, the pain was super bad. The pain was just bad. What does adding super do to it? That might be a bad example, but there are instances where people just tack on a little word that, sure, it carries some weight, but ultimately it just takes time to read, and it does not actually provide any additional information to the adjuster or the attorney or the judge. It's not useful at all. And so if you keep those words out, and that's kind of been my goal as I write, if I keep out any unnecessary words in it kind of just fact. Each sentence should just be kind of a fact, and oftentimes points to some sort of evidence backing up that fact. It sounds super simple, but just keep everything to the facts.
And it's interesting you say this because I've had both your experience of being the young person at a law firm working for a woman who was my mentor and the person who eventually talked me into going to law school and becoming a lawyer, and being asked to draft a letter for her and feeling like, it's lawyers, whether it's vitriol or spin or English that you put on the words and the unnecessary embellishment and the demonstration that I know these big words, therefore I am putting them in a letter. I would write a draft letter for her and it would go back for editing 5 times for a single paragraph. One paragraph, enclosed, please find the following. The benefit of that was she took the time to train me. What I see with people who come to us, they oftentimes have that same piece. In order to argue the case, you've got to be argumentative. In order to demonstrate, you have all those extra words. And it takes a lot of unlearning to take someone from being a writer to being a good legal writer, where that it's the stacking of the facts that build the argument, not the arguing of the facts that make the argument. Does that make sense?
Makes a lot of sense, and I completely agree.
It's been neat working with you and watching the way your writing has gone from where it started to where it is at this point, where it's unusual for me to have a lot of feedback in terms of the detail. And that, again, I think is the fact piece of writing.
Yeah, I think back to the very first demand I wrote at this firm. I drafted it. I sent it over to Hendrik for his review, and he sent it back with some revisions. And then I got a phone call, and then it was a 90-minute phone call. And I remember having felt so intimidated after that call. I thought to myself, I am so far from being a effective legal writer, yet here it is, my job to write demands. So I'm going to have to work on this. It's frightening because it's something that you realize people work on for so long, their writing skills, how to write effectively, and just seeing all of the input that Hendrik had for me on that first demand, I thought to myself, like, this is going to be very difficult for me to write these each time and get them to the place they need to be. But that 90 minutes, I think, was so impactful, honestly, that phone call, because from then on, he would tell me to, cut out unnecessary words, make sure to use active versus passive voice. I was notorious for using passive voice. And as I would write each subsequent demand, the feedback would it would be less revisions in each subsequent demand. And now, honestly, something I've realized is when I write a demand now, it actually feels less daunting because I'm not trying to put together a big, flowery, beautifully read piece. I'm trying to put together my client's story, but in a way that the adjuster can understand it and understands it easily. That's the main goal, that people can read it. They don't have to read it 3 times. They can read it once, they understand it, and then they can take that information and do with it what they need.
As we talk about keeping it short and keeping it factual, you talked about demand packages sometimes being 10 to 20 pages long. I presume that that's not all just verbiage, that you use photos, diagrams, other pieces of information. So while it may be 10 to 20 pages long, a lot of that is visual space and using some creativity to use fewer words where a graphic or an image will be more impactful. Please expand on this in terms of how you approach that for your writing.
Something that I've learned is, I bet you if you looked back at that first demand that I wrote, I probably regurgitated so much of what was found in the medical records. I took a lot of the information that you could find in the evidence, but then I would just kind of reiterate it in my own words. But what I found later is, why do I need to explain what the x-ray found if I could show the x-ray? Or if I could highlight an excerpt from the radiologist's report that says this was the fracture. So now I've got a screenshot of the actual x-ray image itself in the demand that takes up a decent amount of space, but then the adjuster sees the actual fracture. They know the fracture's there. Sometimes you'll do this with police reports. Obviously, if police report is helpful, sometimes you'll include it, excerpts from the police report. But yeah, diagrams are super helpful. Sometimes you might not have an image of your client's injury, but you can find a sample image on the internet, just kind of showing the adjuster, this is what happened to my client. The adjuster is probably going to take a lot more away from a photo than they are from a paragraph, because I know that when they see a paragraph, they probably breeze right over it. Whereas if they see images, they're probably taking a little bit more time to just look at it, soak it in.
We've talked about how you build the package, and we've talked about keeping the words limited. Once you've built a package, do you then set it aside and go through and take time to edit, in essence, take out any of the words that are extraneous, unnecessary spin?
My process, generally, I like to start with almost like a word dump onto the page. By the time I'm writing the demand, I am very familiar with my client's case, generally how their recovery has gone, and in the facts of how the incident itself happened. So by that point, I generally can spend an hour or two just kind of dumping what I know about the case onto the page. And then from there, after that, I will go back through, and you'll be amazed after that first dump, you'll see all of these words that you're just like, yeah, why am I using a 3-syllable word when I could use a 1-syllable word? Or like, I purchased instead of bought, that's something like I'll find those that I can switch out. And then you can cut out words. Excruciatingly painful. I mean, sometimes that excruciating, that is a useful word, and you have to decide when you want to use that. But if I use excruciating every time I use the word painful, excruciating has lost all meaning. So it's, I have to be very selective about the use of those words. So I'll go back through, be like, take out this excruciating here and, this embellishment here. And then after I've done that review, then generally I actually send it to my supervisor, Hendrik, who he'll do a review, and he also will find words to cut out, things to change, ways to just make it an easier, faster, smoother read, but all while maintaining the information that's necessary to convey to the other side.
There is a excellent writer/teacher of writing named Brian Garner, and if anyone has the opportunity to either see one of his webinars on advanced legal writing or attend one in person, he's both a good writer and a good presenter, which is not always common. His methodology is madman, architect, carpenter, judge. And what I heard you talk about is you throw the words down, madman phase. Architect is putting them into order. Carpenter is building them so that they are built into concise pieces. And then that judge piece is going through and stripping and stripping and stripping and stripping. And sometimes that judge piece requires other people, a supervisor, another reader, to go through and make sure that you've stripped it down to its essence.
I think peer review is one of the most valuable things in writing. You could sit there and review your own writing for weeks or months and not catch something that has been right in front of your face the entire time just because you've been buried in it. It's so important to get another set of eyes on your writing. And it's the beauty of working at a firm like Cooper's, people are willing to take a look at your writing and give you feedback and advice as needed.
One of the other areas that I find to be a real challenge in material I review and in things I write, and also when presenting to, say, a jury, is this tendency, particularly in the medical side, to want to demonstrate all of the hard learning that you've mastered. So you can talk about your upper leg bone, or you can talk about your femur. You can talk about your humerus, or you can talk about an elbow fracture. And one of the areas that I find I spend the most time on feedback is simplify, simplify, simplify. That even if you need to be using Google to define each word in a sentence from a doctor's report, that may be necessary, because if the adjuster sees that you can make it simple so that a jury can understand it, then the adjuster is going to be far more concerned that you have persuasive skills than if you dump a bunch of medical or legal jargon in. How do you approach the simplification of the medical injuries?
This is definitely one of the areas where I still get feedback from you sometimes on my demands, especially on the medical side. I've gotten pretty good about using layman's terms for liability arguments, especially when talking about cycling, because given that we represent so many cyclists, a lot of our demands actually have similar conversations around, what cycling means to our clients and how that impacts their lives. So actually, I've had to learn kind of how to write about cycling and what that means to cyclists. I feel like I've gotten pretty good about speaking about that in simple terms. The medical is one area I'm still kind of learning. I mean, this is a practice of law. You're learning just how to present this information. Sometimes it's difficult for me to look at an injury name and try to explain that in a way that is easy to understand, but also still accurately reflects the injury, if that makes sense. That can be a tricky exercise. And so sometimes I'll give it my best shot, and you'll come in and say, well, maybe I would say it this way. A lot of times you've seen the injury before and you've explained it before, and it's something I can take away and use the next time. But I've caught myself more often trying to fix this lately. And one of the things I can think of is I was reading up and down a demand. I had referred to something as a non-displaced hallux fracture, which is just a big toe fracture. Why am I calling it a hallux fracture? In this case, he had fractured his big toe. So go forward, refer to it as a big toe fracture. Makes a lot more sense than a hallux fracture. And something I can still improve on, and I'm sure I will continue to work on in my career, but it is important to speak in simple terms.
And I can think back to times where I had a sentence from a radiologist in a report where it was important information, but almost every single word in that sentence, I ended up having to Google to find a more simplified word, and then go back and make sure that it actually conveyed, as you said, that it conveys what is intended after you've done the simplification. But it's that simplification of language that makes it more effective at the end of the day.
Right. And I'm not a doctor. So when I'm reviewing the medical records and I see the doctor list the diagnoses and it's medical jargon, sometimes it's most comfortable to just transpose that information directly into the demand. It's safe. I know that, the doctor said this was the injury. So if I put it in just like that in the demand, then that's accurate. Whereas if I kind of tweak the language around, try to make it a little more simple to understand, I could end up, if I'm not careful, listing a different injury. And then my demand is no longer accurate. So that's where you have to be very careful, and you want to make sure that when you are simplifying things, you are still talking about the same thing or the same injury, because it's obviously crucial that you are accurate.
Switching gears a little bit, as one seeks to keep the material interesting for the reader, do you ever find time where you reference to a movie called Office Space back in the day, Pieces of Flair, where you add a little piece here or there? And here I'm thinking about a quote from a movie or a reference to some other piece in order to help bring the reader in a little bit more than just a standard legal argument or demand.
Yeah. So me personally, when I kind of take a step back and think about sending demands over, and in my situation, it's to insurance adjusters, I think about the fact that they're getting so many of these all the time. They're reviewing them. But for the most part, a lot of the information in most of these demands is consistent across all the demands, right? It's an introduction of what happened. How did the event occur? How did this vehicle failed to yield the right of way, blah, blah, blah. Talks about the medical treatment and then kind of goes into pain and suffering. And while every incident is different, I don't think you're ever really going to pique the adjuster's interest in explaining how the collision actually occurred. Or you're not going to interest the adjuster in presenting your theory of liability. They're never going to find that interesting. The best place to make your demand a more interesting read, more entertaining read even, is the non-economic damages or pain and suffering section, if you will. And some clients will, a lot of this information comes from the client. It's telling their tale about what they've been doing, or how they've been since the incident. But if you have a client who was very active in the community or physically active or a world traveler, or, they had something prior to the injury that was interesting and, the injury kind of derailed that. I always recognize that as my opportunity to kind of show the adjuster, this is where my client is different than a lot of the clients you've seen before. My client does this odd little thing on the side. And I guess what I'm trying to say is I think the most interesting things to include in a demand are the things that might be different. Something that the adjuster might just go, I've never thought about that, or I've never seen a client with that. It sets your client apart from some of the other demands they've read.
We had a fellow who got struck and ended up with a collarbone fracture. And in the course of being evaluated for surgery, learned that unrelated to the incident, he had developed, I think it was non-Hodgkin's lymphoma. And he immediately went into chemo and treatment where they couldn't surgically repair the collarbone fracture. Now, because he ended up vomiting a lot from the chemo, his description of the grating of the bones back and forth in his collarbone as he had to lean over to vomit every time was different than any other collarbone argument we have made in a demand package. And it was very effective. And that was an area where listening to the client, taking the time to hear them, as opposed to, it's another client with a collarbone, but actually recognizing that every single person that we represent is an individual with a unique piece, then gave ammunition to help make something clearer to the adjuster in terms of the harm that somebody suffered.
Yeah, to kind of summarize this, as I said, the adjusters, they're reading so many of these demands. Realistically, we're never going to write in such a way that the adjuster's like, man, that was interesting. I would love to read another demand from Tim Micheal and Miles Cooper. They're never saying that. But they might see a demand and go, well, now that is an interesting client. They've got themselves an interesting case. Make the demand interesting for the adjuster, both writing-wise and content-wise.
This is an important point because one of the things that sometimes happens is in an effort to make something interesting, one can go too far. And I will tell a story about myself where I kept thinking, these poor adjusters, all they need is somebody creative. And I wrote, in essence, a short story. Every single detail of the case was woven in there.
Right.
But it was a short story of what happened to this person, thinking, oh my God, if I received this, I would be so much happier reading this than something else. And the first thing I got back was, this is really hard to find the material I need to tick all the boxes for my carrier. Can you give me a normal demand packet?
A normal demand package. Yeah. So then you turn around and undo all that work you just did essentially. But the idea was there.
This goes back to, it's great to be creative and it's great to add things, but it's also, you got to recognize the world in which you are playing in. And this is where peer review, if I had peers at that time who could have said, hey, that's creative, but you want to write a short story, go write short stories, but not for the demand.
Yeah, peer review is important. I really appreciate all that comes with peer review.
Well, Tim, thanks again for being on the show.
Thank you.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions you have on making your demand packages most effective in terms of the legal writing that you use. Like what you've heard, share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.